Three. In MS
D. Kolita.
D. Kolita. Learned counsel representing Mr. Asarava.
Yes,
Asarava.
Lordship. Yes, Lordship. Kindly, after 2 weeks, Lordship.
Paid for listing of the appeal after 2 weeks. MS A. Begum. Learned additional public prosecutor for the respondent number 1, State of Assam. Is present. Have you informed this the legal counsel?
No, Lordship.
As per for list the appeal of the.
Actually, I was searching, but she is not visible in the court.
You inform MS M. Bormon. MS M. Bormon.
Highly obliged.
Are they 15?
Yes, counsel. So you are waiting for which item? Let me make it clear, because this item will take up first 15, right? Then we'll take up 16, extensively hard. So thereafter, so let me make it clear so that you are not busy here. So I don't think first up. Will you? যেহেতু এইটো আছে না 16 এই পানী গিলাচটো গুচাই দিওঁ এই পানী গিলাচটো গুচাই দিওঁ আৰু এই বাটনটো গুচাই দিয়ক মাউচটো বৰ দিগদাৰী হয় Prosecution agency People, 6 option. PW3. Robbie Chowter. In his testimony, stated that the house of the informant and his deceased brother, Robbie Jajuar, were located near his residence, Gustav. Deposing on the incident, PW7 stated that on that day he heard hue and cry from the emanating from the house of the deceased, Gustav. Family members of the deceased arrived at his house and informed him about the incident. On receipt of the information, he went to the house of the deceased and saw the accused shouting in pain. Saw the accused lying in the courtyard of the house of the deceased and shouting in pain because of injuries on his neck. It was thereafter, police personnel arrived at the PO and took the injured accused to the hospital for medical treatment. PW7 further stated that when police personnel broke open the door of the room of the deceased, he witnessed the deceased lying dead in a room of his residence. PW3 further stated that the deceased used to reside alone in his house and the accused came to the house of the deceased 2 days prior to the incident for stay. Full stop. PW7 further stated that two wooden piras, 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 were seized, two wooden piras, and a dhow were seized, provide two seizure lists, comma, exhibited by him as EXT2 and EXT3 respectively. Besides identifying his signatures appearing therein. Full stop. P3 also exhibited the dhow, seized as exhibited the two seized bidas as MAT EXT1 and seized dhow as MAT EXT2. Full stop. During cross-examination, PW7 stated that PW3 stated that the accused was shouting in pain while lying in the courtyard of the house of the deceased, and he witnessed cut injury on the neck of the accused. Full stop. PW3 also stated that the deceased was in the habit of consuming liquor. Full stop. PW3 also stated that he did not know how the deceased and the accused sustained injuries on their persons, and he did not read the contents of the seizure list, EXT2 and EXT3. Full stop. PW4. PW5, Motias 4. Oh, sorry. PW3, no? PW4, Augustine Barla. Used to know the informant since deceased, the deceased and the accused. As they hail from the same village also. As regards the incident, PW4 testified to the fact that when the incident, it was at around 10/11 p.m. The incident took place, and at that time he was in his house. Full stop. He stated that the houses of the informant since disease and deceased were located near his residence. On the relevant date, the informant came to his house to inform that there was hue and cry in the house of the deceased and requested him to come to the house of the deceased. Full stop. Accordingly, he accompanied Ruby Chowtal, PW3, and the informant and on reaching the PO, he noticed that the accused was lying in the courtyard of the house of the lying and shouting in pain in the courtyard of the house of the deceased with injuries on his neck. Full stop. It was PW3, Ruby Chowtal, who informed the police about the incident. আয়ো কি কৈছিল বাৰু আয়ো কোনোবা ইনফৰ্ম কৰা বুলি কৈছিল আয়ো PW 14 19:8. I received telephone information from PDB personnel. END 280. The police personnel arrived at the PO after some time and took the injured accused to the hospital for medical treatment. Full stop. PW4 stated that he also accompanied the injured accused to the Jorhat Medical College and Hospital. Full stop. PW4, you question broke open. PW4 stated that when police personnel broke open the door of the room of the deceased, he saw that the deceased was lying dead in a room of his residence. PW4 further stated that the deceased used to reside alone in his house, and it was prior to 2 days prior to the incident, the accused came to the house of the deceased for stay. Full stop. Like PW3, PW4 also exhibited the seizure list, EXT3 and his signature therein as EXT32. Full stop. He also exhibited the seized DAO as MAT EXT2. Full stop. During cross-examination, PW4 iterated that the accused was shouting in pain and lying in the courtyard of the house of the deceased, and he witnessed cut injury on the neck of the accused. Full stop. PW4 also affirmed that the deceased was in the habit of consuming liquor. Full stop. Like PW3, PW4 also stated that he did not know how the deceased and the accused sustained injuries on their persons. Full stop. 6. 6. P6. Manuel Siddiq was another neighbor of the deceased. And he also knew the informant since deceased and the accused, who was a related brother of the deceased. First of, in his testimony, PW6 deposed that on the date of the incident, the accused came to the house of the deceased and stayed there. Post of, hearing shouts of the neighborhood people, he came out of his house and saw the accused lying with injuries in the courtyard of the house of the deceased, with blood oozing out from the injuries. Post of. At that time, the door of the house of the deceased was found closed. In the meanwhile, police personnel arrived at the PO and opened the door of the house. So then he saw that the deceased was lying dead inside his house with cut injuries on the right hand, right shoulder, full stop. PW6 further stated that none was present in the house of the deceased except the accused on the relevant date. Full stop. PW6 further stated that he was present when police personnel seized the 2 Eden Piraj and 1 Gamusa from the house of the deceased by CGR list, EXT2, wherein he put his thumb impression. Full stop. In cross-examination, PW6 stated that he could not say if any third person had come to the house of the deceased on the relevant date. From a reading from on from reading the testimonies of the prosecution witnesses, that's PW3, PW4, and PW6 together. It emerges that these 3 prosecution witnesses had arrived at the PO immediately after the prosecution witnesses PW7 and PW8. Full stop. When they arrived at the PO, they found the accused lying in the courtyard of the house of the accused, and the accused was shouting in pain as he had sustained injuries on his neck. Full stop. It has further emerged that police personnel arrived at the PO after these three prosecution witnesses, PW3, PW4, and PW6. Full stop. It was after arrival of the police personnel at the PO, comma, the door of the house of the deceased was opened. Full stop. By the police person. Full stop. From the testimonies of PW3 and PW4, in their testimonies, PW4 and PW3 and PW4 stated that the door had to be broken. The door was broken, door was broke open. Door was broke opened. And it was thereafter, they witnessed that the disease was lying dead in a room in his residence. Full stop. PW6 also, from the testimony of PW6 also, it has emerged that the door of the house of the deceased had to be opened. Full stop. Right. It is revealed from the sketch map of the PO EXT 6. There were only two rooms in the house of the deceased. Full stop. PW1. Zirimia Topno. Is a co-villager. Who is a co-villager? New. The information is diseased, the diseased and the accused. Full stop. PW 1 stated that he arrived at the PO only in the morning on the following day. On the day, morning or on the following day. Full stop. He stated that when he arrived at the PO, he did not find the accused there. Though there was presence of police personnel. PW1 had, however, stated that he noticed cut injuries on the neck and other parts on the person of the deceased when the dead body of the deceased was kept in the police station. Full stop. When inquest proceeding was held, he stated that the police held inquest on the dead body of the deceased and PW1 exhibited the inquest report as EXT1 and his signature appearing therein as EXT11. Full stop. In cross-examination, PW1 stated that he did not know anything about the incident. Full stop. PW2, Samuel Topno. Also knew the informant since the disease and the accused, as he is from the same village, Sereli, Guhaigaon. Full stop. On the incident, PW2 stated that the incident occurred in the night hour and it was the mother of the accused who telephonically informed him about the incident and requested to come to her house. PW2 stated that the mother of the accused stated to him that the accused had done something. So accordingly, he visited the house of the accused. He visited the PO and saw the dead body of the accused, deceased, lying on the ground with injuries on his neck and other parts of his body. Custom. Like PW1, PW2 stated that police personnel held inquest on the dead body of the deceased at the house of the accused in his presence. So PW2 exhibited the inquest report as EXT 2, which is signature appearing therein as EXT 1-2. In cross-examination, PW2 stated that he did not know anything about the incident. Para. PW5, Matias Pingra. Also knew the informant, deceased, and accused as here his co-villagers. PW5 stated that he arrived at the PO only in the morning hours on the following day. He stated to have witnessed the dead body of the deceased, which was lying inside a room of the house of the deceased. He stated that he came to know from the villagers that the accused was taken to the hospital for medical treatment. PW5 further stated that the 2 wooden pillars and 1 gamusa were seized from the house of the deceased vide seizure list, EXT2, wherein he subscribed his signature as EXT22. PW5 also exhibited the said 2 seized wooden pillars as MAT EXT1. In cross-examination, PW5 stated that he did not have any personal knowledge about the incident and he did not read the contents of the seizure list, EXT2 when he subscribed his signature. From the testimonies of PW1, PW2, and PW5, it has emerged that they arrived at the PO after the accused who was taken to hospital for treatment, medical treatment of his injuries. These witnesses had, however, witnessed that the when they arrived at the PO, they saw the disease lying in a room inside his house with injuries on his neck and other parts of his person. Police personnel arrived at the PO prior to arrival of these 3 prosecution witnesses. When police personnel seized the objects by the 2 seizure list, EXT2 and EXT3, these prosecution witnesses and conducted the inquest proceeding. These prosecution witnesses, my name, Asil 2, inquest Asil 2, PW1, PW1, 2, আৰু 5 আছিল জানে। When police personnel held inquest proceeding, PW1 and PW2 were present at the PO post. Co-parent. এইটলৈ হ'ল। এইটলৈ হ'ল। নাইনটো গ'ল। নাইনটো কোৱেশ্যন হ'ল একবাৰত। নাই। PW9, Noami Jajwar is the daughter of the informant, Zarobian Jajwar, since deceased. The deceased was her paternal uncle. And the accused was her related paternal uncle. So, according to PW9, the incident took place at around 11 p.m. on 19/8/2018. And she went to the PO after about 1.5 stroke 2 hours. In her testimony, PW9 stated that she accompanied her father, the informant, since deceased, to the house of the deceased. And she noticed that the deceased was lying dead in a room inside his, lying dead in a room with cut injuries on his neck, lying dead in a pool of blood. with cut injuries on his neck. Post of witnessing the dead body, she out of fear returned back to her house. Post of PW9 claimed to have noticed the accused lying in the courtyard of the house of the deceased with cut injuries on his person. Also, PW9 stated that the injured accused was taken to hospital by persons for medical treatment. Post-op. PW9 stated that she did not know who had caused the injuries on the deceased and the accused, and whether any third person had committed the incident. At this juncture, it appears appropriate to turn to the medical evidence, which are in the form of the testimony of the autopsy doctor, PW10, and the postmortem examination report, within bracket EXT4. Prior to postmortem examination, inquest proceeding on the dead body of the deceased was conducted by the circle officer, Titabo Revenue Circle, and the PO. At around 9 a.m. on 20/08/2018. Post of after conduct, after completing the inquest proceeding, the circle officer, Titabo Revenue Circle, recorded his findings in the inquest in the inquest report EXT1, wherein the informant, since disease, PW1 and PW2, signed as witnesses. As per the inquest report EXT1, there were injuries, cut injuries on the neck, on the neck, shoulder, cheek, and head. of the deceased. Postal. Para, subpara, okay. PW 10, Dr. Ved Propas Gupta was, on 28/2018, serving as demonstrator, Department of Forensic Medicine at the JMCH postal. In his testimony, PW 10 stated that he performed a postmortem examination on the dead body of the deceased on that day. At around 12 p.m. At around 12 o'clock. And after performing the autopsy, he found the following. Page 26. A2, page 28. A. PW 10 stated that in his opinion, he reported that the death of the disease was due to hemorrhagic shock as a result of the injuries sustained on the person of the deceased. According to him, he found all the injuries were antemortem in nature and were caused by sharp cutting heavy weapon. He stated that the death was homicidal in nature. An approximate time since death was 8-16 hours. PW10 exhibited the PMA report as EXT4 and his signature therein as EXT41. PW10 also identified the signature of Dr. K.C. Das, Professor and HOD, Department of Forensic Medicine, ZMCH, and Police Surgeon Jorhat, Assam, in EXT4 as EXT42. The autopsy doctor was not cross-examined by the defense. From the testimony of the autopsy doctor PW 10 and the PMA report EXT4, it can be safely concluded that the date of the disease was homicidal one. It has from the it has further emerged that the deceased sustained two chop wounds and 5 incised wounds on his person. And those wounds were caused by sharp-cutting weapon, according to the autopsy doctor. তাৰপিছত সেইটো লিখিব, তাৰপিছত সেইটো safely concluded, which I did not. আগৰ লাইনটো পিছত interface the issue which is arising is that who had caused the act of homicide and whether the accused was the perpetrator of the crime. The prosecution witnesses PW one, two, three, three. Eight, nine. Two days priorly within correct. Your question. PW3, PW4. PW6, PW7, and PW8. I had stated that from the testimonies also mentioned, it has emerged that on the preliminary that the accused was staying in the house of the deceased. The deceased, it has further emerged that the deceased used to stay. It has further emerged that otherwise, the deceased used to stay alone in his two-room house. from the testimonies of the prosecution witnesses, comma, it is established that the incident occurred in and around midnight hours on the midnight hours in the night intervening 19/8/2018 and 28/2018. Full stop. Hmm? Okay, right, please. That part of the testimony of these prosecution witnesses the part of the testimonies of these witnesses that of these prosecution witnesses that on the relevant night the accused was staying with the deceased was asked to the accused when he was examined under section 313 CRPC. In reply, Commander accused stated that on that day, he came to the house of the deceased and they dined together. Full stop. The accused further explained that as it became too late for him to return to his house, the deceased asked him to stay with him in his house. Full stop. Accordingly, he slept in one of the rooms of the house of the deceased. Full stop. The accused further stated that at night, the deceased went outside feeling warm, and at that point of time, at that time, someone assaulted him and he became unconscious. Later on, he found himself in the hospital where he came to know that the disease was no more. Close stop. He further stated that he sustained the injury on his neck and he gained sense only at the ICU of JMCH. The accused claimed ignorance as to how the disease sustained the injuries, while stating that he also sustained injury and was admitted into the hospital. Oslo. Espera. CW1, Dr. Nijamuddin Khan was, on 28 2018, posted as registered ENT department, ZMCH. Postal. It was at around 3 a.m. on 28 2018. He examined the accused and found a cut injury over anterior part of the neck, exposing the arytenoids and cricoids cartilage. Postal. The injury was, the wound was repaired in layers and tracheostomy was done on 28 2018. Full CW1 stated that the accused was admitted into the hospital on 28 2018 and was discharged on 17 9 2018. Postal. Court exhibit, page 247. Court exhibit. Yes, where is the court exhibit? CW1 99. CW1 exhibited the injury report of the injured as court ext-1 and his signature therein as court ext-1 in bracket 1. Postal. In cross-examination, CW1 stated that the surgery done upon the injury was life-saving, and had it not been done, the patient would have succumbed to the same. Postal. From the from the evidence of CW1, it has emerged that the nature of injury sustained by the accused was grievous and was caused by sharp weapon. Fine. Against the job. Yes, MS Bormon, anything on this point? Because prosecution has not explained how he sustained. But disease also is not, simply he said that someone assaulted me.
Motive for his concern might be ability to discredit by the valid witness. On the basis of witnesses,
Motive
explanation would have been.
Motive. Plays a role in a case based on circumstantial evidence, but that is something which is in the mind of the accused. It is
Evidence lead to the.
difficult to lead evidence always. It has to be inferred from the testimonies of the witnesses. Now, how he sustained injury, that is still not emerging. But at the same time, his explanation appears to be also false. He said that I lost consciousness, I gained consciousness in the ICU.
PW6 also says there was none except the accused.
That's the perplexing one.
That it's the last person who spent the night, but.
Yes, now it emerges from CW1 at 3 o'clock he was examined. So what is the police station? What is the police station? Borhola. How far? MS Begum, Borhola, from Borhola to Jorhat police station. We should also assure ourselves, that is why.
That is
How far?
near.
What Google says? Borhola to Jorhat police station.
10 minutes. Not that was.
What Google says?
I'll have it.
1 hour 7 minutes. So he started at around 2 o'clock.
2 o'clock.
Ambulance
Ambulance. Reached there within
at night.
at night.
He dined in the house
Lordship. Time period.
Too
is
late
very
in the house,
Very short.
too late in the house, too late to go back home. Then they slept. The incident occurred. So it would be about only 4 hours, say maximum.
It's
Dined,
dying.
slept.
Slept within that
It was
period.
too late.
Too late.
Then if ambulance had taken him to
Hospital.
hospital, then 108 to reach Borhola, somebody had to inform. That will take another at least 30 minutes
30 minutes.
minimum. So it goes back to about 1 o'clock.
When he was in Lordship.
And somebody says it was about 11. So 11 and 1. So this man was with the disease. Disease sustained 7 very serious injuries.
serious. He gave one, he gave 7.
Maybe
That is there.
because
The-
there is no case of, say, disease attacked. Might have attacked.
Might. Because
One, and he is in the habit of consuming liquor.
That is the thing, Lordship. After consuming, he has given 1.
One
And
against
Against-
1 might be 7.
7.
Only one murder weapon.
Taken away from him and chopped.
Quick succession. Then he also, then how the door was closed? From outside. 1, then 7. Then he fell on the bed and this man went out. But tying the door of the house from outside. Then shouting mama. And his mother himself is testifying. And his sister-in-law.
6
And he was not in intoxicated condition, perhaps. Doctor is not saying anything.
PW2 also said, Lordship, the mother of the accused telephoned me and request me to come to her house as the accused has done something. That is there. Her mother herself will never say this.
Mother would not say that much.
That much. That is Lordship.
Mother would say to that extent which is unavoidable.
Unable. She was sure that something has been done. After the incident, he has closed the door, Lordship.
you owe an explanation. Because none of these witnesses were inimical to you. Had it been, the law is now, had those witnesses been inimical, one is your sister-in-law, one is your mother, and other are independent witnesses, and they have not testified wrongly that disease has sustained a number of injuries, and they were categorical that you sustained an injury on the neck. Their testimonies are consistent, reliable, and there is no cross-examination that they were inimically disposed towards you. Then, otherwise, non-explanation by the prosecution is a very crucial aspect regarding injuries sustained by the accused. It says that the omission on the part of the prosecution to explain the injuries on the person of the accused assumes much greater importance where the evidence consists of interested or inimical witnesses, or where a defense gives a version which competes in probability with that of the prosecution one. But your theory falling flat, your explanation is false. You said that I felt unconscious. But after that, you went to the courtyard. Secondly, how can the disease, after sustaining 7 injuries, going outside the home, feeling warm, and come back and lay down on his bed to have these two, that he went outside. Disease went outside, feeling warm. That is one. And you were there inside the room. And while sleeping, someone, then how this man who sustained injuries outside, 7,
Come inside the house.
and come and sleep. And you, who was injured inside the room, went outside and crying mama. And on the other hand, you said, I felt unconscious and I regained sense in the ICU. But 7 witnesses are saying you are shouting. Maybe that disease, you had some fight. Disease made the first move.
That was there.
In intoxicated condition. Then you snatched
Talking to
Judah, thou, inside the room, went outside, then mama, then everybody heard you, came to the place of offense.
He was not
I
in a
think-
position to run away. And the accused was not in a position to run away. Otherwise, he would have.
No, otherwise you would have.
He would have.
That is why mama, otherwise
For safety of life.
this word comes when everyone is in extreme pain. We'll come back. It is there. Where the evidence is so clear and cogent, so independent and disinterested, so probable, consistent, and creditworthy that it far outweighs the effect of the omission on the part of the prosecution to explain the injury, then it goes against the accused.
May please lock it. My lord, in
Okay.
item number 1, my lord wanted to speak with him.
Yes. Okay, your representative was there, proxy counsel,
Yes, my lord, he has not.
so your name will be recorded.
My lord, will my lord just record that mediation terms in the order and terms of the mediation that will be
Oh, you
helpful.
said that Mr. Sakuri said that he doesn't want to pursue the appeal.
Yeah, my lord is recording that.
Hmm.
And there is an entry motor in the IA, my lord, that may be.
Recall.
That's all. Deep joke. And my name was there, my lord, AB Days. Thank you.
The Supreme Court meeting. Of Supreme Court. ये हमारा एससीसी को लाभ होगा बहुत इधर सुप्रीम कोर्ट एससीसी को लाभ होगा ये लाइव उनके क्रिमिनल रिलेटेड ये यूट्यूब वगैरह तो पैरासेरा नहीं बहुत इधर एक बुझ ना पाए क्रिमिनल लॉ जाने itu masukkan ke pasal 7 kabupaten same thing SCC boleh dia kan criminal SCC আমার অনলাইন অফ ক্রিমিনাল লজ এন্ড প্রসেস লেভেল বুঝছে itu বড় ফ্রি করে হয় লাভ সাইন দিয়ে দিও হ্যাঁ from a cumulative analysis of the entire evidence materials on record, it has emerged that including the testimonies of the prosecution witnesses, the explanation provided by the accused during his examination under section 313 and the testimony of CW1, the scenario which has emerged is that in the night intervening 19/8/2018 and 28/2018, the accused who was staying in the house of the deceased. Full stop. The deceased used to stay in his alone in his house, in his two-room house. Full stop. From the explanation given by the accused, it is clear that in that night, he came to the house of the deceased and thereafter, they dined together. Full stop. As per the version of the accused, as it became too late for him to return to his house, which is otherwise in the same village, he stayed in the house of the deceased at the request of the deceased. Full stop. From the testimony of PW, CW1, the accused was examined by him at the JMCH at 3-05 AM on 28/2018. Full stop. From the evidence stroke materials on record, it has emerged that the accused was sent from the PO to the JMCH for treatment of his injuries by one 108 ambulance. Full stop. If the distance between the place of occurrence at village Sereli Guhaigaon under Borhola police station and the JMCH is considered, it might have taken at least an hour to take the injured accused from the PO to the JMCH. Full stop. In such scenario, the accused appeared to have been taken by the 108 ambulance from the PO at around 2 AM. Full stop. The as per the testimony of তুমি একটা কল করেছিল 108 অ্যাম্বুলেন্স আর ফোনে করেছিল কোনটা করেছে কোনটা করেছে Who called ambulance? From the PO? Somebody called in ambulance. Somebody called. Hmm? Mhm. Hmm? PW? 4.
Page number 14.
Ah.
That's why he. Second last line.
Page?
Is 14. Total PW inform police about the incident.
No.
But it's in the,
IO. IO was there.
in IO lordship,
Ah.
it stated that
Ah.
some unknown person have assaulted one
Ah.
and has been lying on the ground and they have rang up 108.
That I have seen. ZD entry was exhibited. From the testimony of the IO PW4, it has emerged that he received he received telephonic information from VDP personnel that at Sereli Gukhaigaon, some unknown persons had assaulted one person and he was lying on the ground in assaulted one person, and they had rang up 108 ambulance to ship the injured to the hospital for medical treatment. Post-op. From such testimony of IO PW14, it emerges that the ambulance was called on 19/8/2018, meaning thereby prior to 12 o'clock, intervening 19/8/2018 and 28/2018. Full stop. And the incident wherein the disease and the accused sustained injuries occurred prior to midnight. Full stop. PW9 testified to the fact that the incident occurred at around 11 p.m. on 2018. So stop. When all these facts are considered together, comma, it emerges that it has emerged. It is established that the incident wherein no, and the cost of repetition, comma, it may be mentioned that the accused himself had said that on 19 on that night, in that night, comma, he and the disease dined together, and it became too late thereafter, comma, for him to return to his house. So when all this were considered together, comma, it emerges that the incident wherein the accused, both the deceased and the accused, sustained the injuries comma mentioned above in between 11 p.m. and 11 p.m. on 2018 and 12 o'clock of the night intervening 2018 and 2018. Houston. It is not the case of the defense during the trial that the accused was not in the house of the deceased. We find that in the above fact situation, comma, a reference like and a reference to the circumstance of last seen together can be referred to also from the proposition principle laid down by the courts in a long line of decisions, comma, the circumstance of last seen together would normally be taken into consideration for finding the guilt or otherwise of an accused in respect of the offense charged, which, when it is established by the prosecution that the time gap between the point of time when the accused and the deceased who were found together alive and when the deceased was found dead is so small that possibility of any other person being with the deceased would completely be ruled out. Full stop. The time gap between the accused person seen in the company of the deceased and the detection of crime is a material consideration for appreciation of the evidence and placing reliance on it as a circumstance against the accused. Full stop. There is, however, no fixed or straitjacket formula for the duration of time gap, and it depends upon the evidence laid by the prosecution to remove the possibility of any other person meeting the deceased in the intervening period. First, meaning thereby, comma, if the prosecution is able to lead such evidence that likelihood of any person other than the accused, comma, being the author of the crime, comma, becomes impossible, comma, then the evidence of circumstance of last seen together, comma, can be considered as one of the circumstances in the chain of circumstances to prove the guilt against such accused person. Full stop. If it is demonstrated that the accused person, if it is found out, if it is found out that the accused was at the place where the incident occurred or where the accused was last seen together with the deceased and there was no possibility of any intrusion to that place by any third party, then it would become a circumstance in a case resting on circumstantial evidence. Full stop. Mhm. Mhm. Mm. At this juncture, we also find appropriate to refer to the principles of law governing the applicability of Section 106 of the Evidence Act. So as per Section 106 of the Evidence Act, when any fact is spatially, the silo of Section 2, within the knowledge of any person, the burden of proving that fact is upon him. Full stop. The word. Full stop. It is true that the ordinary rule that applies in a criminal trial is that the burden always lies on the prosecution to prove the guilt of the accused. And the said rule is embodied in Section 101 of the Evidence Act. Section 106 of the Evidence Act is an exception to Section 101 of the Evidence Act. Full stop. The rule of evidence embodied in Section 106 of the Evidence Act is designed to meet is applicable in certain exceptional cases in which it would be impossible or it is impossible or becomes extremely difficult for the prosecution to establish the facts which are especially within the knowledge of the accused and which he can prove without difficulty or inconvenience. Full stop. In Trimukh Maruti Kirkan versus State of Maharashtra, 2006, 10 SCC 681. Honorable Supreme Court, while considering a case of homicidal death, in the confinement of a house, has observed that if the offense takes place inside the privacy of a house, and in such circumstances where the assailants have all the opportunity to plan and commit the offense at the time and in the circumstances of their choice, it will be extremely difficult for the prosecution to lead evidence to establish the guilt of the accused if the strict principle of circumstantial evidence is insisted upon by the courts. Full stop. It has been observed that a judge does not preside over a criminal trial merely to see that no innocent man is punished. A criminal trial is presided over not merely to see that no innocent man is punished. And it is also presided over to see that a guilty man does not escape, as both are public duties. Full stop. It has been further held that the law does not enjoin a duty on the prosecution to lead evidence of such character which is almost impossible to be laid, or at any rate extremely difficult to be laid. Full stop. The duty on the prosecution is to lead such evidence which it is capable of leading, having regard to the facts and circumstances of the case. Full stop. When an offense like murder is committed in secrecy inside a house, the initial burden to establish the case is undoubtedly upon the prosecution. But the nature and amount of evidence to be led by it to establish the charge cannot be of the same degree as is required in other cases of circumstantial evidence. Full stop. The burden is the burden is of a comparatively lighter character. Full stop. In view of Section 6 of the Evidence Act, there is a corresponding burden on the inmates of the house to give a cogent explanation as to how the crime was committed. Full stop. The inmates of the house cannot get away by simply keeping quiet and offering no explanation on the supposed premise that the burden to establish its case lies entirely upon the prosecution, and there is no duty at all on an accused to offer any explanation. Full stop. From the in state of West Bengal versus Mir Muhammad Omar and others, reported in 2008 SCC 382, the Supreme Court explaining the rule of evidence embodied in Section 106 of the Evidence Act, has laid down the following principles, para 31 or para 34. Oops. এই 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 এটা ক্লিপ মারা আছে যে ক্লিপ এটা মারা আছে ক্লিপ qualify as a piece of evidence, piece of the evidence, but the inculpatory aspect as which emerges from the state may be seen to land identification taken to examine the evidence. Prosecution has been able to lead satisfactory evidence on the aspects where on all the possible on all the possible aspects for it to lead to establish that the accused on the relevant night was in the company of the deceased inside the house of the deceased, and the incident wherein the deceased sustained the injuries of the nature, mentioned here in above. Posted. The there is no manner of doubt that the prosecution witnesses PW3, PW4, and PW6 are independent witnesses. So the defense did not elicit anything from these prosecution witnesses. To show that these prosecution witnesses were inimically, adversely disposed towards the injured in any manner. Full stop. Their testimony are well corroborated by the testimony of the prosecution witnesses PW7 and PW8, were closely related to the deceased and the accused. For that matter, more closely related to the accused than the deceased. First of PW7 is the mother of the accused, who testified to the effect that who along with mother from these prosecution witnesses, from the testimonies of these prosecution witnesses, it has emerged that the disease was found lying with injuries inside a room of his own house. And at the same time, the accused was found lying in the courtyard outside the house of the deceased. Full stop. These prosecution witnesses had also testified that the door of the house was found closed from outside. Full stop. The in charge Bekajan outpost, PW 13. Had stated that not 13, not 13, 12. Who visited, who reached the place of occurrence along with the IO. So who said that? But a question now?
Side.
No. 11. No, circle office. Sorry. The circle officer who at the PO conducted the inquest proceeding on the dead body of the deceased, deposed to the effect that the door of the house was tied by some rope-like substance. Postal. The said fact was elicited by the defense during cross-examination of PW 11. Close from outside by the public. Postal.
Taken NOC from us, so our
Mhm.
name may be strike out.
LOC. Huh?
NOC.
NOC.
Yes, my lord.
6 is tied up with 5.
Hmm?
Item number 6.
Yeah,
No,
made
no,
it.
no, actually it's only 6.
Only 6.
Yeah, Matt appeal, no?
Yeah, made it.
Made appeal. You are for appellant or respondent?
Petitioner.
Yes, no?
The-
Any replacement?
I don't know something. I don't know lots of.
Hmm.
They have taken NSC formulation.
Yeah.
They have taken NSC formulation here. So.
MS. Your name, please.
S Podel.
Hmm?
S Podel.
S.
Podel.
Portal. You are appearing for KK Monto.
My lord.
Learned counsel appearing for Mr. KK Monto, learned senior counsel for the appellate. Learned senior counsel has submitted that the brief has been taken back. by the client by providing NOC. And as such, they are, and as such, command a set of councils whose names are reflected in the cause list are no longer, would no longer be appearing for the applicant. Posted. In view of such submission, with the case after 3 weeks, as none has appeared for the appellant to the on call.
Highly obliged.
Shakalo picture, na? 11 begin. Full stop. We now turn to the explanation provided by the accused during his examination under section 313 CRPC. Now turn again, huh? Turn again. The accused stated that on the relevant day he came to the house of the deceased and he and the deceased dined together. So as by the time it became too late for him to return home, and the deceased requested him to stay back in his house with him, he stayed back and he slept in one of the rooms in the house of the deceased. Stop. The accused further stated that at night, the deceased went outside feeling warm, and at that time, someone assaulted him and he became unconscious. Stop. Later on, he came to know at hospital that the deceased had already died. Stop. Para. It is true that the accused had sustained an injury on his neck on the night of the incident, as reposed, as corroborated, as testified by the prosecution witnesses and CW1, and demonstrated by EXT 8. His injury report, EXT 8. Full stop. The accused did not provide any explanation on the point that when he was assaulted inside the house of the accused, how he came to the courtyard of the house of the deceased. Full stop. The accused had asserted that he, after being assaulted, comma, became unconscious. Full stop. The said explanation of the accused is contrary to the testimonies of the prosecution witnesses, comma, PW 3, PW 4, PW 6, PW 7, and PW 8, who testified that when they reached the PO, almost instantaneously after the incident of assault, that to the effect that the accused was found lying in the courtyard and he was found shouting, writhing in pain, WRITHING, with an injury on his neck. Full stop. The in such uh, the testimony and the explanation of the assertion of the accused regarding his unconsciousness has turned out to be a false one in the face of the credible evidence that he was found shouting in the courtyard of the house of the deceased. Full stop. Where objection এটা কোনটো দিলে মুন্না 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 চাওঁ the accused as the door. Full stop. If it is also not comprehensible to not comprehensible as to how the deceased was found lying inside his room with so many brutal injuries on his person when, according to the accused, the deceased went out of his house feeling, yes, feeling warm. And as to why the door of the house of the deceased was found closed from outside. Closed up. The explanation provided by the accused, such explanation provided by the accused, clearly turned out to be a false one. Full stop. In the fact situation obtaining in the case, in the peculiar fact situation obtaining in the case, it was expected of the accused to render proper explanation for the injury sustained by him and as well as for the injuries sustained by the deceased, and also for the fact and also for the fact that why the door of the house of the deceased was found closed from outside. Full stop. The accused was found opting to provide no explanation as regards the injuries sustained by the deceased and had opted to name no one for the injuries sustained by him. Full stop. It is settled that it is a settled proposition that if the accused gives incorrect or false answers during the course of his statement under section 313 CRPC, the court can draw an adverse inference against him. Full stop. Failure on the part of the accused to give an explanation or giving of a false explanation is an additional circumstance, is to be treated as an additional circumstance against the accused. Full stop. A false answer offered by the accused renders the circumstance capable of inculpating him. Full stop. In a situation comma as obtaining in a fact situation comma as obtaining in the case in hand comma such a false answer can also be counted as providing a missing link for completing the chain. Full stop. Suresh 2015 আর একটা সুরেশ আছে 2000 আর একটা আছে মুন্না কুমার ফাইট আছে 2000 It is true that if in a particular, if there is omission on the part of the prosecution to explain the injury on the person of the accused, sustained by him at about the time of the occurrence. No. It is true that in a case like murder, the non-explanation of the injuries sustained by the accused at about the time of occurrence is considered to be an important circumstance from which a number of inferences, adverse to the prosecution, can be drawn. However, there may be cases where the non-explanation of the injuries by the prosecution may not affect the prosecution case. Full stop. The second principle applies to cases where the evidence is so clear and cogent, so independent and disinterested, so probable, consistent and creditworthy, that it far outweighs the effect of the omission on the part of the prosecution to explain the injuries. Full stop. Bracket REF Locksmith Singh and others versus State of Bihar. Full stop. On or after giving our NCS consideration, we find that the present one is a case where the second proposition is found applicable. Posted. Such view of ours also stems from the fact that the accused did not provide any explanation whatsoever as to how the deceased had sustained so many grievous injuries on his person. Full stop. এটা এনে দেওনন্দন মিশ্ৰণী কিবা এটা দিছিলো হা মানে দেওনন্দন কিবা এটা কৈছিলো কোনোবা এটা কেছত সেইটো মনত ৰাখি থব দেওনন্দন লিখি থব আৰু মটিভ এটা পেৰা চাই দিম having considered all the evidence to materials on record in its entirety, comma, we are persuaded to arrive at an unhesitant view that the prosecution has been able to prove all the circumstances by cogent and credible evidence pointing towards the accused as the probable assailant and non-explanation on the part of the accused as regards the injuries, as regards the injuries sustained by the disease and the injuries sustained by him and his false explanation as regards the entire incident of assault leading to the homicidal death of the deceased has completed the chain of circumstances to indicate that to unerringly indicate that he was the responsible for commission of the crime of murder. Full stop. Consequently, comma. As a result, comma, we affirm the we are as a result, comma, we are of the considered view that there is no reason to interfere with the judgment and order of conviction and sentence passed by the learned trial court against the accused appellant. Full stop. Affirming as the appeal is found not merited, comma, we affirming the judgment and order of the learned trial court, comma, dismiss the present appeal. Full stop. Compensation আছে জানো এইটো okay para we reiterate the direction given by the learned trial court as regards disbursement as regards disbursement of compensation. Adequate compensation to the family members left behind by the deceased. In terms of section 357 in A of the code and the extant victim compensation scheme 2012. First of the case records so and so trial court be sent back for it. কিন্তু তবে মোটিভৰ ওপৰত লিখিব লাগিব। That's good. Motive present in the case. Yes, some circumstantial evidence. Then. Oh, M. Mormon. Appreciation.
Item number 16.
Yes, 164.
Yes, my lord.
Did it suffer from any infirmity?
Few judgments, my lord, I'd like to rely upon. In the factual part, my lord, we are already completed.
On the last occasion, your lordship made the query.
Yes.
As it is 164 statement. And the Lare trial court didn't rely upon it, whether the appellate court can still.
No,
reappreciate.
firstly, regarding 164, let us test ourselves.
Yes, whether, yes,
Thereafter, we'll
lordship. My-
fall back to that
My lord.
Second part, my lord,
principle, whether appellate court.
second part, my lord, did some research, not on the direct point. Got one judgment of the apex court, my lord, where the accused was charged under 306 as well as 498A. On 498A, he was acquitted by the trial court, but convicted under 306. There was no appeal filed by the state on the acquittal of 498A. In spite of that, the High Court reversed. Apex Court said that ought not to have been done.
But in your case, it
In-
can be done.
In my case, it is,
It is possible. I have seen many, at least I can quote 5.
my lord, I got on
I
appeal
can
against
quote
acquittal.
5.
My lord.
I am in a position to quote 5, at least. So second aspect, no
So
issue.
let us go into the first aspect.
Have you found something?
Independently.
Independent, whatever is reached. Forget about those findings, reach your independent view. That is a law. Because it is the same charge and conviction.
Yes. My lord, one is 2010, 2110 SCC, page 725, my lord.
Yes, Mr. Dhar and Mr. Bhagavatia, we don't think your case will be reached. If this is complete, we'll start dictating. Yes, Mr. Prosecution, are you waiting for something? Yes, which part?
No, my lord, first 2007 12 SCC 230, my lord.
I am holding 2021.
My lordship will kindly take up 2007 12 SCC 230.
MS Thakuria? I don't think.
Please. Alok Nath,
We should not keep you waiting.
para 87, my lord.
Alok Nath.
Yes,
Extrajudicial confession, judicial confession, retracted judicial confession.
from 87 onwards, my lord, confessions generally.
Hmm.
Three things, my lord. With regard to voluntariness of the confession, truthfulness of the confession, and corroboration. Then 89, my lord.
Hmm.
Then from 91, it is on retracted confession. Lordship may turn to para 95. Article 23.
Yes.
Then Lordship 99.
Yes.
104, my lord.
Yes.
So here also, my lord, in this case also, it is a case of a retracted confession. Whether the guidelines laid down by the apex court as well as this honorable court were followed, my lord, by the Indian side.
Just for a moment, the query of the court is very limited. That if the accused was not asked by the magistrate that whether you make confession or do not make confession, in neither of the situation, you would be sent to police custody again. That is the specific query of the court. Not saying this part or this question will affect or vitiate the making of such judicial confession or recording of such statement under section 164 CRPC. I think this is the specific query of the court.
Then, my lord,
This Alok Nath, whether
no,
it
my
has
lord,
addressed,
to
it is
that-
the
yes.
broad contours. Within that broad contours, that specific query,
then I'll take your lordships to the our judgment of our High Court, my lord. It is reported in 2022 4 GLT 679. I have given the Manupatra printout is available with me.
I find very difficult to read Manupatra.
No, it is clearly paragraph mark. From 25 onwards, man. Lordships have got it. Should I read, my lord?
Yes.
The learned judicial magistrate who recorded the statement of the appellant under section 164 was examined as PW 11. He stated that the confessional statement made by the appellant was recorded by him on 9/6/99 after giving proper warning and sufficient time for reflection. He has exhibited the confessional statement as exhibit number 8 and his signature as exhibit so and so. In his cross-examination, he stated that the cautions given by him to the appellant was recorded in exhibit 8 and that the caution given by him were not recorded in the order dated so and so passed by him. From the above discussed evidence, it appears that except the confessional statement recorded by PW 11, there is no other substantive evidence against the appellant. Though the learned session judge relied on the evidence of PW 5 and 7, their evidence does not reveal any substantive leading to the conclusion that none other than the appellant had caused the death of the deceased. Now the question is whether the said confessional statement can be acted upon. The learned counsel appearing for the appellant has strenuously argued that the said confessional statement was not a voluntary one and as such, the same cannot be relied on. We have carefully perused so and so. Admittedly, the appellant was arrested on 6/6/99 and he was produced before the learned CJM on 8/6/99 and the learned CJM referred the matter to PW 11 for recording the confessional statement and the confessional statement was recorded by PW 11 on 9/6/99. From the above, it appears that the appellant was kept in the judicial custody, that is jail hazard, from 8/6 to 9/6. Therefore, it appears that he was produced before PW 11 after about 48 hours from the time of his arrest by the police. This indicates that he was in the custody of the police for a considerable period. From Exhibit 8, that is the form of recording confessional statement, it appears that the learned magistrate recorded the following questions put to the appellant and answers thereof given by him. I am not a police but a magistrate. I know. You are not bound to confess the guilt. I know. During the course of trial, the confessional statements may be used against you. You shall not make any confession as per the version of others. You shall not tell a lie. You confess your guilt. After giving the said cautions and explaining the consequences of making the confessional statement in the above manner on 9/6, the learned judicial magistrate decided to record the confessional statement and kept the appellant in the chamber in the custody of his office peon from 12:30 to 4:30 p.m. Therefore, the appellant was given about, I think this should have been 3 to 4 hours, time for reflection. After giving him the said caution, the learned magistrate on the first day of the production of the appellant before him on 8/6 did not caution the appellant that he was remanded to the judicial custody without giving the said required warning and without explaining the consequence of making confessional statement. Before recording the confessional statement, the learned judicial magistrate put the above 6 questions and recorded the answer given by him. In his answer to question number 6, the appellant stated that he killed the deceased in self-defense. Carefully perusing the said caution recorded in the form of recording confessional statement, we find that the appellant was not sufficiently assured that in the event of refusal to make confessional statement, he would not be given to the police custody again. Therefore, in our considered opinion, the appellant did not get assurance from the court that he was free to confess his guilt, if any, voluntarily, without having any fear of going back to the police custody. In the absence of any assurance in this regard, it cannot be concluded that the appellant was free from fear of being sent to the custody of police again. In our considered opinion, the said evidence and the manner in which the confession recorded do not inspire confidence to believe that the said confessional statement was freely, voluntarily, and without any influence or threat.
What are the evidence? Otherwise,
In this case,
because trial court said it was a sole basis.
it was the sole basis.
PW2 declared hostile, PW3 declared hostile. One is hearsay. PW1 hearsay. PW5 hearsay. PW6 hostile. IO. Seizure. PW8 seizure. PW9 hostile. Disclosure of present without. PW7. One, two, three. 5, 10, 6. Veracity. Not inclined to believe. PW3. Assault to record over. Assault to record over 164, exhibit 12. Where is question number 3123?
Hello?
Page 90 and in between 90 and 91. 91 page starts with question number 4. Was there any questions number 1, 2, 3?
Oh, it is not there in my book also. Check the record. NCR.
Next option, one statement. What is the date of recording the statement?
29th. 29/12. Arrested on
When
27th.
he was arrested?
27th. Page 89, he was remanded to judicial custody, 28/12.
Sequence. At the time of lodging the affair, the accused was in custody? No. So
I think at
he
that
was,
time
he was under detention in police station for only 1 hour
from the record.
And also from the questioning and eliciting answer in the 164 statement, he was arrested at Burlengi something at 8:30 AM and detained at, what is the police station?
Khotkhoti, I think.
Khotkhoti for about 1 hour before being brought to court. This is also a factor
But
because a forwarding report is also dated 28/12/2000.
so he was more than 1 day, my lord.
Who?
27, on 27th he was arrested. On 28th he is produced. Page 89. The order remanding to judicial custody is of 28th.
Yes, he was never in police custody.
No, from 27th,
No, he was never arrested.
when was he arrested? He was arrested on 27th, my lord. "27th, my lord, he was brought by the local people.
Let us see the sequence first.
Yes.
The FIR was lodged, first the incident, on 26th. 26/11 is the incident.
Yes. 26th.
Right. Now the FIR was received at a police station at 3 p.m. on 27/12/2015,
Yes.
page 1.
Prior thereto, my lord, it was on the basis of a GD entry.
It was the entry.
GD entry.
Now, when let us see the IO.
Yes, IO, my lord, 31 page.
Uh,
Page 31. At around 4:10. Hemraj given information. Accordingly, GD entry was made.
mhm. When the GD entry was made,
4:10 of 26/12, page 31.
I have recommended on previous day, GD entry was.
Fourth line from the top.
Yes, I went to the place of occurrence on 26. 4:30. Cinema start.
Page 32, my lord, around 6-7 lines from the bottom.
Hmm.
At 2 p.m. that day, the accused was brought to the PS on 27th. Thereafter, on 28/12, after medical examination, he was sent to judicial custody.
It's about then, So at 2 p.m. on 27/12/2015, the accused was brought to the police station. So less than 24 hours. Okay. Let us see the testimony of PW 14.
He's 24.
34.
When this 313 was done, 2019.
19.
At the stage of 313, you said that I did not confess.
confess.
So about 4 years. There was nothing in between, nor in the cross-examination.
There is nothing.
Yes.
On this aspect, my lord.
These are the questions asked in
Yes,
this
one-
case.
one more judgment, my lord. Just one paragraph, my lord. 2011 2 SCC 490.
Given. Or this Monopatra is in GLT already, I think you have provided
Yes, yes.
in earlier round perhaps.
No, my lord, list of books was given, my lord. I already had copies.
Already there.
Para 64 of the judgment, my lord. Not on the factual part, my lord.
Oh,
but-
Dara Singh, staying.
Yes,
Which part?
64, my lord. At page 521 and 522. The following principles emerge with regard to section 164. The provisions of section 164 must be complied with not only in form but in essence.
Hmm.
Before proceeding to record the confessional statement, a searching inquiry must be made from the accused as to the custody from which he was produced and the treatment he was been receiving in such custody. In order to ensure that there is no scope for doubt of any sort of extraneous influence proceeding from a source interested in the prosecution. A magistrate should ask the accused as to why he wants to make a statement, which surely shall go against him in interest in the trial, his interest in the trial. The maker should be granted sufficient time for reflection. He should be assured of protection from any sort of apprehended torture or pressure from the police in case it declines to make a confessional statement. A judicial confession not given voluntarily is unreliable, more so when such a confession is retracted. The conviction cannot be based on such retracted judicial confession. Non-compliance of section 164 goes to the root of the magistrate's jurisdiction to record the confession and renders the confession unworthy of credence. During the time of reflection, the accused should be completely out of police influence. The judicial officer who is entrusted with the duty of recording confessions must apply his judicial mind to ascertain and satisfy his conscience that the statement of the accused is not on account of any extraneous influence on him. At the time of recording of the statement of the accused, no police or police official will be present in the open court. Confession of a co-accused, my lord, this is not necessary. Usually, the court requires some corroboration from the confessional statement before convicting the accused person on such statement. So our High Court judgment, my lord, is in tandem with this, my lord. He was not given that assurance. No. The question of one with regard to 106, my lord.
Who made the confessions?
My lord.
In Dara Singh.
Dara Singh, my lord, factual part.
In what context these observations are made?
No, this, if we read, my lord, 64.
No, we have to read only not 64.
Not just 64. If
Ah.
we read 64, it is after
It
discussing
is Dara Singh's confession
after
or
discussing
somebody
everything,
else's.
my
No,
lord.
no,
After-
please,
This
please.
is of a co-accused, Maharaj.
Then section 30.
Section
30. It is section 30.
of the evidence.
This, yes, yes.
Yes,
Obviously, I have
I've
seen
that,
it.
my lord.
I have seen.
It is co-accused.
Is it Dara Singh? No.
Now, what I am on is 64 is a
No,
summary,
this is
my lord.
specifically, this or these guidelines
Yes.
are not specifically to the confessional statement. It is confessional statement of the co-accused. If you read all the previous paragraphs.
Let me read 56, my lord. before analyzing the confessional statements of various accused persons and their applicability and the procedure followed by the magistrate in recording the statement, let us consider various decisions touching these aspects.
Right. This Robin, this is only there is. Okay. Confession. Section 154. Elaborating non-compliance.
Very good.
Is so before admitting the mistake of these persons. And the applicability. Let us consider the touching on this aspect. First precaution is required to prevent forcible extraction. Is also held that provisions of section must be complied with in essence. Assessing inquiry. Then we have been listening. It must be made to the accused from the source. And
Para 58 may also be seen.
it's possible. Yes.
69 may also be similar. Sixty-eight and 69.
Does it answer the question, that query,
My lord,
that if that is not done, what will be the consequence?
I think, my lord, in my respectful submission, our High Court judgment answers that query, my lord. The question of the Abdul Subhan judgment answers that query. My lord. If that is not done, it will vitiate. And once in my respectful submission, para 64 of Dara Singh, my lord, that summarizes the law with regard to 164, my lord. It, in my respectful submission, it does not pertain to confession of a co-accused. Section 30 of the Evidence Act, my lord, is of a co-accused. Here 64 is in general with regard to 164, and from the reading of the earlier paragraphs, we can come to that conclusion, my lord. Here it deals with everything. Because in the case of Abdul Subhan, my lord, it has been rightly held that if he is not assured, in para 32, that he will not be sent to police custody again, that assurance is not given, then it cannot be said to be voluntary.
Yes.
Actually, my lord, I'd not like to trouble your lordships by repeating, my lord. Actually, we have already concluded, my lord. PW1 doesn't say that it was seized from the body on 27th. Mhm. It is only- Mhm.
Yes. Yes, anything more?
No, my lord. Mhm.
Lordship, first I take your lordship to the judgment of the learned trial court, madam.
এইটো ফাইল কৰোঁ এইটো হেৰি হাজবেণ্ডটো ওলাই দিবচোন
Para 24, page 54.
নহয় কিন্তু ফাইল কৰোঁ চুমান খালি হৈছে বহুত দুটা আছে এই 1957 SCR 953
Para 24, madam.
Hmm.
The evidence of PW 14 shows that he warned the accused that he was not police but a magistrate and that he was not bound to give confession statement. If did so, it would be used as evidence against him. Exhibit 13 is the order by which PW 14 recorded confession statement of the accused. Exhibit 13 does not show that prior to recording the confession statement, he warned the accused as stated in his evidence. In view of the discussion made above, I have come to conclusion that the confession of the accused person marked as Exhibit 12 was not recorded in compliance with requirement laid down in section 164 CRPC. Now I take your lordship. My lord.
as stated in his evidence. Magistrate. Conviction.
1957 to 1 SCR or something.
Yes. Why he did not explain?
Lordship, I'll be
So
giving
prior to
emphasis
Sunday, you weren't accused.
regarding warning part.
Huh? What? I am not understanding this paragraph 20.
Lordship, from where she has like.
I
learned
don't
trial court.
understand. The evidence of PW 14 shows that.
Yes,
That is his testimony.
yes,
He warned the accused that that he was not police, but a
Yes.
magistrate. And that he was not bound to give confessional statement. If he did so,
it
it
would
will be
be used
used
against him.
as evidence against him.
Yes. PW 13 is the order by which PW 14 recorded. Exhibit 13 is the order by which PW 14 recorded confession statement of the accused. Exhibit 13 does not show that prior to recording the confessional statement, was it a requirement, my lord, under the law?
I don't know.
I don't think so. Under the High Court rules, it's a stipulation has been given. If during that proceeding, certain question answer form and rules are given by the Honorable High Court, my lord, how the confession statement are to be recorded. So this is
Question is
warning
there, do
beforehand,
you know, if you confess the accusation, it may be used against him, you.
my lord,
That question was there, that answer was there.
my lord. So let us see, my lord, exhibit 13, my lord, once. Page 97.
Then,
It's nothing, my lord.
you
CR
know that you are not bound to make confession.
No, prior to that, page 97, my lord.
No, I am
She's
reading
talking-
the original
yes,
one.
Yes, my lord.
Original one.
No, she's talking, learned trial court judge is talking about exhibit 13, my lord, at page 97. CR put up to me for recording statement of accused Sri Lakhon Goyali under section 164 CRPC. Afterwards, statement recorded, CR returned back to the original court. Lordship, I don't think there is a requirement that before recording, Lordship, so, Lordship, the face of it, my lord, the learned trial court misunderstood the provisions of law, your lordship, and did not consider the 164 statement. And your lordship, now I take your lordship to the 164
He
statement.
discarded the statement
He discarded.
because 24 hours reflection time was not given, perhaps. Is it not? Now let us pair 23.
Para 23. Now, let us see first whether the confession statement
Was
of the accused.
45 minutes reflection time.
Lordship,
Now a great question has come
my lord.
to my mind, whether 45 minutes time can be considered to be adequate for reflection. In a case of murder, where the so-and-so has been murdered, as your own murder in view of it, I am of the opinion that 45 minutes is not at all adequate. That is the finding.
My lord.
That is the finding that 45 minutes was insufficient
My lord,
for
my
reflection.
lord.
I think that is the understanding that he was brought
My lord,
from jail custody on 29/12/2015.
lordship, my lord.
Then this magistrate gave how much time for reflection in his court chamber?
45 minutes.
45 minutes. So that is not sufficient according to
Right.
this. He ignored the jail custody period.
Lordship,
Okay, then relied on Sarwan Singh,
Sarwan
Ratan
Singh.
Singh. Let us see what it observed. Long, lamba. Okay, then para 14,
Lordship,
that he was of the view that in the order sheet also, those things are to be reflected.
my lord.
So I have come to the conclusion. Marked as so-and-so, not in compliance. But so far as
Lordship, I'll be relying on Sankaria judgment, but there's no straight jacket formula, my lord.
no straight record.
Lordship. So, in the event of the matter.
It is a magistrate
My lord. It is satisfaction of
has
the
to-
magistrate.
get satisfied himself
Lordship,
that now the accused is in a position to make confession voluntarily, and he appears to be outside the police influence.
lordship.
Now, what the purpose then, whether any influence, promise, force, threatening was made to you by police or any other person for making the confession? No. Do you know
Lordship.
that you are not bound to make confession?
My lord.
Yes. Then the question, do you know that there is no police officer associated with the investigation in the vicinity and you are completely under liberty to confess about guilt? You need not be afraid or to speak. Yes.
Lordship, that page 94, whether any influence, promise, force or threatening was made to you, police.
I've seen.
Yes.
I have seen.
And now your lordship will consider his evidence, my lord, evidence of PW 14.
PW 14.
Lordship,
1 minute. Before that, let me see song for you.
Sankaria, your lordship.
No, Sarwan Singh.
Sarwan Singh, Ratan Singh. Para 10 may be relevant.
Ah,
Lordship.
misunderstood perhaps. The judgment has been misunderstood.
Oh.
When an accused person is
Lordship,
produced
please read the
before a
paragraph.
magistrate,
May I know, my lord, paragraph?
paragraph. Firstly, I have seen the head note, but anyway. We'll find out the paragraph, but this is the sum and substance.
My lord.
When an accused person is produced before the magistrate by the investigating officer It is of the utmost importance that the mind of the accused person should be completely freed from any possible influence of the police. And he must be sent to jail custody and given adequate time to consider whether he should make a confession at all. Ordinarily, he should be given at least 24 hours to decide. On 28, he was produced by the IO before the magistrate. He was sent to police custody to be produced on that day, next day. That, in that context, said 24 hours. This is the reflection time, not this 45 minutes.
Lordship,
Anyway, it might be inside. SCR is the Supreme Court, Honorable
Well,
Supreme
please.
Court's own journal,
Yes. Page 966.
own journal. I
966.
don't think they will be wrong in editing.
No, Mala, 966 it is clear. Page 966, around 1, 2, 3, 4, 5, 6, 7, 8, around 9 lines from the top. The whole object of putting questions. The whole object of putting questions to an accused person who offers to confess is to obtain an assurance. 24 hours is from, my lord, reading of the judgment is jail custody. Of course, that will be, my lord, after he has said that he will make a confession. SCR is better.
paragraph 10, SCC online.
Yes. The SCR judgment are now paragraph number.
Paragraph 10.
That SCC is better. Should be serving the SCR number.
The evidence of magistrate Mr. Grover shows that accused was produced before him at 2:30 p.m. He was given about half an hour to think about the statement which he was going to make, and soon thereafter the confessional statement was recorded. Half an hour recorded directly after produced before him. This is the case. This 45 hours, 45 minutes, as reflected in paragraph 23, we are not in agreement with that.
No, that part is not in sync with this judgment also.
No, because
Yes.
to disagree,
Yes, yes.
that is the context in which I have put the query to you, that whether we can, after disagreeing, because this part has been discarded, 164 was taken out of the purview by the learned trial court. We are on the point that whether we can disagree. After disagreeing, we can reach our own finding. That is the query.
Then in Sankaria judgment, it has been typed.
Sarkaria, what did it say?
Lordship, paragraph
Citation to-
44.
Paragraph
Citation is
44.
1970, 3 SCC 435,
1970.
8, 3 SCC 435. Shankaria versus State of Rajasthan, 1978, 3 SCC 435. Here also Sarvansing has been discussed. Your
Four?
Lordship. 435,
435. Sarkaria.
yes. Shankaria versus State of Rajasthan.
Yes, please read.
Lordship, para 43. In Sarvansing versus State of Punjab, this court had emphasized that before recording a confession, the magistrate should see that the mind of the accused person is completely free from any possible inference of the police. In that context, it was observed that the effective way of securing such freedom from fear to the accused person is to send him to judicial custody and give him adequate time to consider whether he should make a confession at all. In this connection, it is suggested Speaking generally, it would, we think, be reasonable to insist upon giving an accused person at least 24 hours to decide whether or not he should make a confession. The court was careful enough to preface this suggestion with a remark that it would naturally be difficult to lay down any hard and fast rule as to the time which should be allowed to an accused person in any given case. It will be seen that how much time for reflection should be allowed to an accused person before recording his confession is a question which depends on the circumstances of each case. The object of giving such time for reflection to the accused is to ensure that he is completely free from police influence. If immediately before the recording of the confession, the accused was in judicial custody beyond the reach of the investigating police for some days, then such custody from his very nature may itself be a factor, dispelling fear or influence of the police from the mind of the accused. In such a case, it may not be necessary to send back the accused person for any prolonged period to jail or judicial lockup. In the instant case, the accused was got admitted to the judicial lockup on June 12 for getting his confession record.
Yes.
My lord,
Yes, yes, please
should
continue.
I carry on?
Yes.
Yes. Getting his confession recorded under 164 CRPC, and such admission was made under the orders of the magistrate, who ultimately recorded his
Victim boy.
confession on June 14. The accused was about 2 days in judicial custody beyond the reach of the police. On June 30, 1974, a written request was made to the magistrate by the police for recording a confession of the accused. Even then, the magistrate postponed the recording of the confession till the following day, obviously because he wanted to give the appellant 1 day more in judicial custody to ponder over the matter free from police influence. On June 14, notwithstanding the fact that the accused Sankaria was in judicial custody from the evening of June
30
12.
hours.
Yes.
30 hours.
My lord.
30 hours.
Yes, my lord. Allowed 15 minutes more time for reflection. And para 51 maybe.
15 to 20 minutes
Lordship,
for reflection
my lord,
before the magistrate.
lordship.
এইটু পারবে ছেড়ে ছিলাম ক্লাস না শেয়ার বেশি থাকছে Yes, anything more?
Lordship, I think magistrate has covered that he has like under 281, Lordship, in his testimony, my lord, that he had fulfilled all the formalities, my lord. And there is no cross-examination to that effect, my lord.
What about section 463?
463.
Uh,
Error.
See, that is specific to 164.
63.
It often gives. Read
Yes, my lord. If any,
why magistrate comes into picture.
yes. If any court before which a confession or other statement of an accused person recorded or purporting to be recorded under 164 to 81 is tendered or has been received, in evidence finds that any of the provision of either of such sections have not been complied with by the magistrate recorded statement, if in it may not, so it's telling anything contains 91 of the Indian Evidence Act, like evidence in regard to such non-compliance and may, if satisfied, that such non-compliance has not injured the accused in his defense on the merits and that he duly made the statement recorded amidst the statement. So like, so when the magistrate in his testimony, lordship deposes that he fulfilled all the formalities, my lord, and there is no,
Subsection 2 also.
the provision of this section apply to courts of appeal, reference and revision.
To enable the court to take evidence in regard to any non-compliance in detect. The police advisor will not injure the accused in his defense on his however. King's caution to the referee that he was not found to make such confession have been administered by the police officer concerned as he showed to see the action not felt necessary in the instant case.
Lordship, probably the magistrate had fulfilled in his
This is to be
testimony.
looked into in a context of 463 also.
My lord. And in his 313, my lord,
Yes,
lordship, he said, I did not confess that I murdered the deceased. My signatures obtained in confessed and marked as so and so without explaining the contents to me.
yes, can
That
be
plea he has taken after a period of 4 years, your lordship.
something which is not believable that it is going against a judicial officer. Yes. What interest does he play? Yes, anything more?
Lordship, the testimony of PW 14. Lordship, I've already seen it. I think it
Magistrate,
covers, yes,
magistrate.
yes, my lord. He cautioned, he explained the matter of confession to him. He cautioned him, my lord. And there was repeated caution. In spite of repeated cautions, the accused intended to give confession statement voluntarily. After making due inquiry, I came to know that the accused was ready to give confession statement voluntarily. Thereafter, I started recording this statement. And in cross-examination, while for the first time the accused was produced before me, he got nervous. I found the accused physically sound. The accused stated before me that while he demanded the money from the deceased payable to him, the deceased refused the same. Or probably this can be taken as a circumstance.
Very good. The 1994 to SCC 467.
4,467.
PSCC, page 1. Yes, Ms. Bhuya, what do you say about that Darasingh observation, this particular line? I have never seen this in any other case in Darasingh, paragraph 64.
Sorry.
Because that is not the statutory compliance or that requirement. Paragraph 64 perhaps. This Roman 5.
Even if your lordship considers, my lord, 164 statement, the magistrate did not follow certain requirements, my lord.
No, it is not the statutory requirement.
Lordship,
I
regarding-
looked at the provision of section 164.
my lord,
This is Darasingh made
my lord. Then your lordship, if it is
observation,
not a
parameter.
statutory requirement,
No, this is not.
not,
Now, this is Darasingh made
lordship,
requirement.
my lord.
In
Then I have to
no
look up
other,
the-
in no other
did not
cases,
find-
I have made a survey.
My lord,
In no other cases,
No,
that
sir.
is a requirement.
my lord.
And so far as statutory requirement is concerned, under subsection 2, the magistrate has to say that you are not
Bound to-
required. You are not bound to
Bound
make
to
a
make
confession.
confession.
And if you do so,
my lord,
it may be used as evidence against him. And plus voluntary nature,
yes,
voluntary nature
my lord,
of evidence.
my lord,
Because why I am saying
my
so,
lord,
because within first 15 days, otherwise, police can take his remand,
my lord. Lordship,
otherwise.
my lord,
In special cases, it's different,
my lord,
but so far, this will go against
my lord,
another statutory provision.
lordship.
This is what I am finding difficult.
If
Why?
your lordship grants me,
This is one particular thing.
my lord. And even if your lordship discards, for that reason, discards the 164 statement, other circumstances still remain. The
No.
chain is complete, my lord.
We are we are not only discussing one case,
My lord,
Ms. Mia.
lordship,
Why we are
My lord.
concerned,
future,
something we write,
lordship,
it might affect some other cases
lordship.
also, right? That is why we are
My lord.
more concerned. We are not very much concerned in deciding this
My lord,
case.
My lord. Lordship, I understood.
That is the,
Yes,
somewhere out of blue, this Roman 5 has appeared in Dara Singh. But in no other case, this is
My
the
lord.
requirement.
lordship,
This is the man-made law,
my
perhaps.
lord,
This is not statutory,
lordship.
but this has been put in as a precautionary measure.
Oh.
Whether this is a requirement or if not, how
Lordship, don't have that, our form, 164 form. I think it's there, that
not form আছে নহয় আমাৰ?
164 statement.
আৰু এটা বিষয় থাকে over the magistrate, one second.
PW 14, my lord. Record for form নহয়, আছে নেকি? গোটেইখিনি stipulation বিলাক তাতে থাকে ন? Lordship PW 14, page 34. So I think he covers, my lord.
The issue of protection from variable.
Registry for communication. Confession record for form consent, একদম পুরা format টা থাকে।
মানে এই যে পিটিশন Okay. Yes.
Lordship, it's there.
Huh?
Lordship has not seen that form, whether it is there.
I have seen.
It has been made under the High Court rules. I think it's there, that
No, we have formed the opinion.
Lordship.
So I have formed the opinion
My
now
lord.
in the context of Dara Singh. Yes.
Then your lordship, if it goes against us, the lordship's opinion, then I'll rely on the other circumstances.
We will disclose when we dictate.
Other circumstances, I think chain is complete.
Huh?
Lordship, because the
We are not arriving at any view now.
My lord. My lord.
In the last case also,
My lord.
we got confused with the injuries on the accused.
Accused.
Because normally it is to be explained with the prosecution, but in certain situation, not. So that was the view formed while
While
dictating.
dictating. My lord. I leave it to your lordship.
So Yes, madam. Or within that court already. Well, dictate in the court, it will be too short a time, 45 minutes. We can start.
Regarding reappreciation of evidence by the appellate, court, should I submit?
Yes, please, if you have.
May I answer?
So it will be clear.
Dapat diyo mo? Criminal appeal. Supreme Court of India. Jogi and others. Jogi and others were state or employee. This is- Para 9, madam. The High Court, while dealing with a substantive appeal under the provision of sections 374 of the Code of Criminal Procedure, in the exercise of its appellate jurisdiction, the High Court was required to evaluate the evidence on the record independently and to arrive at its own findings as regards the culpability or otherwise of the accused on the basis of the evidentiary material, as the judgment of the High Court indicates, save and except for one sentence which has been extracted above, there has been virtually no independent evaluation of the evidence on the record. While considering the criminal appeal under section 374(2) of CRPC, the High Court was duty bound to consider entirety of the evidence. The nature of the jurisdiction has been dealt with in judgment of this court in Majjal versus State of Haryana, where the court held, in this case, what strikes us in the cryptic nature of the High Court's observation on the merits of the case. The High Court has set out the facts in detail. It has mentioned the names and numbers of the prosecution witnesses. Particulars of all documents produced in the court, along with their exhibit numbers, have been mentioned. Gist of the trial court's observation and findings are set out in a long paragraph. Then there is a reference to the arguments advanced by the counsel. Thereafter, without any proper analysis of the evidence, almost in a summary way, the High Court has dismissed the appeal. The High Court's cryptic reasoning is contained in 2 short paragraphs. We find such disposal of a criminal appeal by the High Court, particularly in a case involving charge under section 302 of IPC, where the accused is sentenced to life imprisonment, is unsatisfactory. It was necessary for the High Court to consider whether trial court's assessment of the evidence and its opinion the appellant must be convicted deserve to be confirmed. This exercise is necessary because the personal liberty of an accused is curtailed because of the conviction. The High Court must state its reason why it is accepting the evidence on record, and the High Court's concurrence with the trial court's view would be acceptable only if it is supported by reason. In such appeals, it is a court of first appeal. Reasons cannot be cryptic. By this, we do not mean that the High Court is expected to write an unduly long treatise. The judgment may be short but must reflect proper application of mind to vital evidence and important submission which go to the root of the matter. Since this exercise is not conducted by the High Court, the appeal deserves to be remanded for a fresh hearing after setting aside the impugn order. Then the Majjal judgment, Lordship, I will just submit it into detail. Then one more, 2013, 9 SCR 257.
It has been quoted, I think.
Yes, it has been. 2013, 9 SCR.
Page number one.
2013, 9 SCR 257. Kamlesh Prabhudas Tanna and another was the state of Gujarat. Para 7 to 13, Your Lordship. Para 7. In the present appeal, we are constrained to note that the High Court has really not appreciated and analyzed the evidence on record, and it is perceptible that it has narrated the prosecution version, referred to the names of the witnesses examined and the documents exhibited during the trial, reproduced the findings recorded by the learned trial judge, recorded a submission of learned counsel for our respective parties, and thereafter referred to the post-mortem report, the FSL report, inquest panchnama, and other documentary evidence, and ultimately referring to the deposition of the prosecution witnesses in a cryptic manner has come to hold that there is no lacuna in the oral evidence, and the same has been duly corroborated by the documentary evidence. The High Court has dealt with the factum of suicide at some length, which is not disputed. Thereafter, there has been advertence to the issue of enhancement of the sentence in the appeal preferred by the state and how the state appeal data made consideration. As we perceive, the High Court, while dealing with the statutory appeal under the Code of Criminal Procedure, has failed to appreciate and scrutinize the evidence in proper perspective and the reasons ascribed as by it for acceptable. The evidence and concurring with the view of the trial court is not supported by any acceptable reason. At this juncture, we are obliged to state that though it may be difficult to state that the judgment suffers from sense reasons, yet it is not at all difficult to say that the reasons ascribed are really apology for reasons. If we allow ourselves to say so, one may ascribe certain reasons which seems to be reasons, but the litmus test is to give seemly and condign reason, either to sustain or overturn the judgment. The filament of reasoning must logically flow from requisite analysis. But unfortunately, the said exercise has not been carried out. In this context, we may refer with profit to the decision of Padam Singh versus TWP, wherein two judge bench, while dealing with the duty of the appellate court, has expressed as it is the duty of an appellate court to look into the evidence adduced in the case, arrive an independent conclusion as to whether the said evidence can be relied upon or not, and even if it can be relied upon, then whether the prosecution can be said to have been proved beyond reasonable doubt on the said evidence. The credibility of the witness has to be adjudged by the appellate court in drawing inference from proved and admitted facts. It must be remembered that the appellate court, like the trial court, has to be satisfied affirmatively that the prosecution case is substantially true and guilt of the accused has been proved beyond all the reasonable doubt, as the presumption of innocence with which the accused starts continues right through until he is held guilty by the final court of appeal, and that presumption is neither strengthened by an acquittal nor weakened by a conviction in the trial court. In Rama and others versus State of Rajasthan, the court has stated about the duty of the appellate court in the following terms. It is well settled that in a criminal appeal, a duty is enjoined upon the appellate court to reappraise the evidence itself, and it cannot proceed to dispose of an appeal upon appraisal of evidence by the trial court alone, especially when the appeal has been already admitted in place for final hearing. Upholding such a precedence would amount to a negation of valuable right of appeal of an accused, which cannot be permitted under law. In Iqbal Abdul Samaya Malek versus Gujarat, relying on the pronouncement of Padam Singh Supra and Bani Singh versus TWP, this court has reiterated a principle pertaining to the duty of the appellate court. Recently, a three-judge bench in Majal, which I have been just referred by now, versus State of Haryana, has ruled thus it is necessary for the High Court to consider whether the trial court's assessment of the evidence and his opinion that the appellant must be convicted deserve to be confirmed. This exercise is necessary because the personal liberty of an accused is curtailed because of the conviction. The High Court must state its reason why it is accepting the evidence on record. The High Court's concurrence with the trial court's view would be acceptable only if it is supported by reason. In such appeals, it is a court of a first appeal. Reasons cannot be cryptic. By this, we do not mean the High Court is expected to write an unduly long treatise. The judgment may be short but must reflect proper application of mind to vital evidence and important submission which go to the root of the matter. And para 12, tested on the touchstone of the aforesaid principles, we find that there is total lack of deliberation and proper ratiocination. There has been really no assessment of evidence on record. The credibility of the witness has not apostately been adjusted.
Well, yeah, all these judgments are Supreme Court's
136,
criticizing
High Court,
weaknesses
my lord,
in the judgment of the High Court,
my lord. No, sure. My lord,
right?
my lord. So I am
Right from
my
Majal and all.
lordship.
Basically, the criticism of the High Court judgment by the Supreme Court.
No, I am placing because on the last occasion of the lordship made the query whether your lordship can independently.
Yes, that
assess.
is the precise
So that
query.
is
This
the
is not the
lordship. So
precise
it is-
answer.
Yes.
This is not the precise answer.
Independent.
These are judgments which are criticizing weaknesses in the appellate judgment of the High Court.
My lord. So in between the observation, whether lordship can assess the independently or
That is what.
my lord.
Anything more?
Sure. Not with that, or it's on the same.
Again, tomorrow is to holiday. Monday, Tuesday, not Friday. Tuesday, not Friday. What you say your question? Who doesn't? Util kami.
So, for instance, question number- Lordship, the sound is done. 28.
No more argument. No more argument.
Lordship.
Okay?
Thank
And Mr. Deka and MS Punya, if you have any other business to conduct, put some proxy counsel.
Yes, on it.
Heart Mr. Hendek. Learn it. Unlike a spirit for the appellant and MSP Punya. Learn it, senior counsel. And additional public prosecutor for the respondent state. Because my esteemed sister will not be sitting on Tuesday. On Tuesday.
On
So there will be, I think, different bands
on
on
Tuesday.
Tuesday.
Right.
That is why I am posting it on Wednesday.
Wednesday.
Next, the case again on so and so at part. For that to be, huh? See? কিবা আছে নেকি আৰু কিবা আছে? Yes, any other matter? Which requires any consideration? What is this case 11, item 11? Anybody present? He is in detention for 21 years. What is the case
No, my
about?
lord, consecutive as well as concur. If I have legal issue I have dealt with, I have seen, my lord.
I have seen.
Yes.
Why he is in custody for 21 years?
No, the lordship on the last occasion. asked me-
Consecutive,
Yes.
right?
No remission, nothing. They have not applied for it.
No, but question is, what are the offenses for which he has been
302,
punished?
302, ma'am.
302, how many? 2?
2%.
Huh?
No, ma'am. उठा दियो ना? Note तो है ना?
Yes. What is the, what is the punishment? 21, 11 to use.
Lordship, life, in sentence the accused person suffer RI for 10 years. Page
1 minute,
99,
which page?
page 99,
Page 99.
Lordship.
Um,
RI for 10 years, then to suffer life imprisonment. And again, 5 years. As
364,
Yes,
then 302,
20134,
under 364, 10 years.
10 years,
And under 302,
life.
life.
Then 20134, 5 years.
5 years. Now the last one,
Lordship.
the sentences will run consecutively.
Consecutive.
Now what is the point of law? If a life imprisonment is there, no?
Lordship.
Still,
My
the
lord.
life imprisonment is there,
My lord.
it otherwise indicates
The complete
Uh,
life of a person.
complete life. Then in what order it will be counted? That first 5 years, then 10 years, then life.
Lordship.
It cannot be the other way around. B Bora. B Bora.
Five judges. 16 or 8.
Convicted several.
Eight assistant. Lordship, 2016, it assisted 3-1.
Yes, I am looking at it.
My lord. Cannot be directed to run consecutive.
No, which paragraph?
Lordship, para 7, your lordship, para 7. Para 33 and 34. It is true that the Supreme Court has in several other cases directed sentences of imprisonment for life to run consecutively, having regard to the gruesome and brutal nature of the offense committed by the prisoner. However, the answer to the question under reference is while multiple sentences for imprisonment for life can be awarded for multiple murders or other offenses punishable with imprisonment for life, the life sentences so awarded cannot be directed to run consecutively. Such sentences would, however, be
But it
superimposed.
is the otherwise it appears if life sentence is there plus other term sentences,
Yes, my lord,
then term sentences will run first.
my lord,
If it is ordered to run consecutively
consecutive
and thereafter life sentence.
life sentence.
That is what it has been held perhaps.
Lordship.
It to go on it. Consecutively now whether you can interfere at this stage on that point.
Scale 92. Can you repeat it again?
Suppose
Hello,
we dismiss the appeal
hello,
on merits,
hello. Lordship,
still
my lord.
whether that part can be modified.
Probably your lordship can. Lordship,
kind
After
of something.
appreciating the evidence,
No,
my lord,
on merit.
my lord. Lordship will
Firstly is,
dismiss
it is
Oh, that part
conviction.
only, consecutive and
Firstly,
concurrent.
302 appeal,
My lord,
364 appeal,
lordship,
201 appeal
Appeal.
by us.
my lord,
Okay.
my lord.
Now next is
Consecutive and
sentence.
Yes, sentence.
Sentence.
Yes,
Sentence under 31, he has specifically
my
said
lord,
consecutive. And if it is not said also as per section 31,
my lord,
then it will run consecutive.
consecutive.
Only when the court
Sentence
observes
con-
that
yes.
it will run concurrently,
My
then
lord.
only it will run
My
concurrently,
lord,
right?
my lord,
Now here is a specific case, it will run consecutive.
my lord.
So this part, whether we can modify
I
from
think your lordship
consecutive,
can. I have not
think
gone through
is one
my-
thing.
Yes. I don't have so much of knowledge while I'm trying to learn
Think
your
is
lordship
one
from the
thing.
book. Yes.
Settled position law is one
I
thing,
know it.
but this thing is not there in statute.
My lord,
This much I am sure.
my lord.
Or we can say 386. Let us just for a moment. We can do so.
My lord.
386.
Oh, lordship, 5.
B, 386.
365.
B,
B.
small b. Roman 3.
Yes.
With or without altering the finding. Say without altering the finding. Alter the nature
My lord,
of the sentence.
my lord.
I think
Lordship may do so.